Good morning, ladies and gentlemen, and welcome to the Second Court of Appeals. We have one case set for argument today, but before we get started, I would like to introduce you to your panel. To my right is Justice Wade Birdwell. To my left is Justice Mike Wallach, and I am Lee Gabriel. So we will proceed if the clerk will call the case.
The court will now call T.L., a minor and mother T.L. on her behalf, versus Cook Children's Medical Group. And may it please the court, Mr. Justice Nixon to argue 15 minutes and 5 minutes for the appellant, and Office of Attorney General will argue second, Mr. Kyle D. Hawkins, for 5 minutes. And Ms. Amy Ward to argue for 20 minutes for the appellee.
All right. Mr. Nixon, you may proceed.
May it please the court, this statute is hopelessly flawed. It lacks every indicia of due process, the result of which is a termination of substantive rights of the mother to direct the care of her child and of the child's life. That's where we are. Now, you've asked us to address 3 questions. Let me get to those first. No, the open court provision is not before the court. The Attorney General may address that, but we have proceeded under a declaratory judgment action seeking a declaration that the statute is facially and as applied unconstitutional, and under a federal cause of action, the civil rights claim. We have not pled an open court violation. Second, and most importantly, there is no right of the hospital to terminate care. This is a very fundamental question. Instead, they have a duty to provide care. Their obligation comes twofold. First, under an agreement with the state of Texas, under the Star Kids program, to be the provider of care in the 6-county area. They've agreed to effectuate public policy of the state to provide for indigent and special needs children. They have a contractual duty to the state. They have a duty to my client to fulfill that obligation. They cannot shrug it off, and they cannot walk away from it. And in fact, I think it was very important that where Cook admitted that they could find no case that supported their claim of a right to terminate care. Instead, they have a duty.
Counsel, I'm sorry. Have we not, on previous occasions, identified the relationship between a physician and a patient as a fiduciary relationship, at least one that is a relationship of trust and confidence between the physician and the patient, such that, under these circumstances, there might be standing on the part of at least the attending to make a determination that, in fact, the best interest of the child would be the withholding of life-sustaining treatment?
There has been no case that allows a doctor to override the decision of a patient or the patient's decision maker.
Well, actually, OG versus Baum specifically, it went to the court to get an order that allowed for the provision of a blood transfusion, and the Jehovah's Witness blood transfusion cases are numerous in this state and in the United States Supreme Court with regard to that.
Well, think about what a blood transfusion is for. It's to help somebody live.
Understood, but is it not part of the duties now with regard to the state to look to determine whether or not care is futile? For example, Section 166.010 specifically says that this statute's subject to the federal child abuse and neglect laws.
Right.
And 42 U.S.C. 5106G and I specifically contemplate that, in fact, life-sustaining care can, in fact, be withdrawn on the basis that the care is futile, that it is not in any way ameliorating or correcting the life-threatening condition of the infant.
In that situation, there is due process. Think about what happens here. the mother is informed, under the statute, does not even have to be in writing. The mother is informed that in 2 days, we are going to have an ethics committee, a meeting of a group of nameless, faceless people who are all employed.
We'll get to due process. I'm trying to figure out, and I want to hear from the state with regard to this, whether or not the state has an interest in alleviating the suffering of an infant that is determined to be, in fact, inhumane or pointless based upon the circumstances of the care.
I am aware of no case in which the state, any state, has intervened for the purpose of bringing about the death of a patient. For the specific purpose, we want the patient to die. I'm not aware of any state or of any interpretation of a statute that says that the government may intervene without due process to bring about the death of a patient because we think it is in the best interest. And think about it. Futile is not defined, and in this case, there's been no specific fact-finding of what futility is.
Understood. But you cited, Counsel, you cited the Supreme Court of Oklahoma specifically saying that that there is, in fact, or at least implicitly recognizing a right, all right? But in that circumstance, we will eventually get to the due process issue because in that instance, it was in fact hearing from an ad litem that had been appointed, and in fact, the court found that it was appropriate for the state, for the judge to enter an order that it was better to withdraw life-sustaining treatment from the ward of the state under those circumstances. So yes, there have been courts that have actually held that the state has that interest. That has never been held in the state of Texas. We're addressing that for the first time. So my question to you, again, is are you taking a position that the state of Texas does not have that interest, or does it in fact have that interest? And if it does, then how does it effectuate that interest?
It has never been articulated by the Texas legislature, the public policy-making body, that it seeks to have that interest. And so we can't read an interest into a statute where there's been no interest effectuated by the legislature. The legislature has said we want to provide care to children. And remember what happened in Oklahoma. The state severed the parent-child relationship under an extensive due process, period. It appointed, the child was a ward of the state, and then we had an ad litem. I mean, there was an extensive and very lengthy due process involvement. Here there is none. So we don't have the interest of the state saying this is what we want to do. We want to intervene in cases and make a hospital a decision maker for us to bring about the death of a child when they think that the care is futile. There's been no articulation that that's the public policy of the state, and it is not appropriate for this court to create that public policy. Instead, it's better to look at the status quo.
So it's your position that 010, which specifically says that this statute is subject to the child abuse and neglect statutes of the federal government, which includes the Child Abuse Prevention and Treatment Act, which I just cited, okay, that is not an articulation by the legislature that at least the guidance that is provided, okay, with regard to that statute and with regard to the federal entities that interpret that statute, we should not be looking to that to inform this court's decision about whether or not the state has an interest that's being argued by the hospital here.
No. Okay. No, and it is very, because all of the statutes regarding children are to provide for their health and welfare, not their death. This is a completely different situation. You know, you have had an impassioned, and most of the briefing of Cook was talking about what they viewed the medical situation as being, and not what the law was. They're making an emotional plea. But remember, look what is the Latin phrase that you have. God is the author of justice. God is the author of life, not the state. Remember, the 14th Amendment exists to restrict the state's ability to take away life. The 14th Amendment does not give life. It comes from our Creator. That is our foundation of our law. So, life belongs to us. The parent-child relationship belongs to the mother. That's where we start. So, we want to protect children from neglectful and abusive parents. Has there been such an allegation here? No. Has there been a fact-finding here? Has there been a fact-finding that care is in fact futile? There's been no such determination by the court. The trial court did not enter any findings of fact or conclusions of law. So we start with the premise that under our common law, that there is a duty to maintain care, and that care may not be withdrawn unless and until, particularly in a situation like this, a person is being given has an opportunity. So the statute says reasonable opportunity. That's not a period of time. That's an event. Have we found, this is a complicated case. You just cannot move to another situation. Of course, and I cited for you the doctor's testimony that he would not sign discharge orders unless it met his specific requirements. So this is a very difficult situation in order to transfer this child to another facility who will maintain the same level of needed care. So, I want to talk a little bit about due process. And that's what's fundamental, and that's what you look at when you looked at the federal statutes for which you earlier asked me. There has to be, in all cases, if you're going to sever the parent-child relationship, and a very important place to look is the Texas Family Code. The Texas Family Code is very extensive on what must happen and what must be pled and what facts must be shown and what level of scrutiny the evidence must meet, clear and convincing, in order for there to be beginning the process of severing the parent-child relationship. What happens here? The hospital gives the parent 48 hours notice of a meeting in which they may attend without an advocate, without producing any kind of controverting evidence. There's no record. There's no ability to cross-examine witnesses. There's no ability to defend yourself, the result of which could be either the loss of your life or the loss of the parent-child relationship. So if the state's going to intervene or allow its agent to intervene, and that's what that's what our claim is about, is that there has been a determination of a violation of our right to life and to self-government without due process. No one, and not even the cook, has defended the due process. And I want to make it very clear. The culprit in this case is the statute. It is not Cook. We're not angry with Cook. It's the statute to which they are seeking to utilize. That's the culprit here. And so when we have a statute which 30 million Texans could be subject to, it's very important that we provide the fundamental rights of life and liberty that the 14th Amendment and the Texas Constitution guarantee us to have. The government will not interfere without accomplishing those due process. The only people that have the ability to interfere is the government, and those are the 14th Amendment and the Texas Article 1, Section 19 are both designed to limit the ability of the government to interfere with the rights to life and self-direction.
Counsel, if we decide we agree with you and the statute is constitutionally infirm from either a procedural or a substantive due process position, what do we do? Because at this point in time, the family code's not been invoked.
Right.
Okay. And we have a trial court that's in an equity position, has the child in front of, has subject matter jurisdiction and personal jurisdiction over the child. Do we apply a best interest analysis with regard to that, or is it still your position that, in fact, there's no standing whatsoever on the part of cooks or the attending to raise an issue with regard to the best interest of the child as to whether or not it might, in fact, be in the best interest of the child to alleviate the pain and suffering that's described in the record?
Right. Of course, you know that the mother disagrees.
Understood.
The mother disagrees with all that.
So how, if we're in an equity position,
Let's assume it's true. Just assume it's true for answering your question.
Right.
All right, here's what you do. You order the hospital to maintain care. Okay? They've agreed, they have a contract with the state of Texas to provide care. The mother, this is a Texas Star child. The mother and baby are entitled to the care pursuant to the Texas Government Code and Health and Human Services agreements, so that you have to maintain care.
that's true even if the care is in fact medically futile or inhumane, as the Child Abuse and Prevention and Treatment Act identifies.
There's been no findings of that, but let's.
Well, no, but we're sending it back under your scenario.
Look,
So you're just basically saying we enter a judgment at that point in time, because there's no 1983 violation if we make that order.
Well, there still is a 1983 violation in the failure to provide due process. Due process alone is intended, we have pled for nominal damages, so due process alone is enough to provide a judgment under 1983. You don't actually have to suffer the loss of life in order to incur damages. Let me answer your question very briefly.
Your
What's your-
time is up, sir, so I'll give you an opportunity to do that when you come back.
Thank you.
Mr. Hawkins?
Thank you, Justice Gabriel, and may it please the Court. I'd like to address the two issues that are actually dispute in this case, and then I would like to address the questions that Justice Birdwell asked Mr. Nixon earlier. The hospital does not dispute that the due course of law requires adequate notice, the opportunity for a hearing before an impartial arbiter, opportunity for judicial review. They don't dispute any of that, and they agree that O46 doesn't provide any of that. Instead, the hospital is really making two arguments. Number one, they're saying that they're not actually depriving anyone of a constitutionally protected interest. And number two, they're saying even if they are effecting a deprivation, they are not a state actor. Both of those arguments are wrong, and I'd like to address them each in turn. First, baby T faces the deprivation of a constitutionally protected interest, that is, her life. On the facts of this case, discontinuing care is a deprivation because it is the real, proximate, and but-for cause of baby T's death. The care that the hospital is providing is what is keeping baby T alive, and ceasing that care will bring about her death. Now, the hospital agrees with those facts, but argues in response that she will not die from the deprivation of care, but rather from her illness. But that's like arguing that plane crashes are caused by gravity. We would never allow an airline manufacturer to escape liability by saying that it was gravity that caused the plane crash and not faulty engineering. In the same way, the hospital should not be able to hand-wave away a deprivation by saying that it's the underlying illness that will terminate life and not their actions. The hospital bases its argument on two cases, and I think it's misreading both of them. One is the VACO case, which they lean heavily on. That is an equal protection case, not a due process case. That case is simply saying that a state does not violate a physician's equal protection rights by forbidding physician-assisted suicide. That dicta that they cite at page 798 of that opinion, page 801 of that opinion, doesn't bear on the due process question before this court. The second case that they lean on is the DeShaney case, but the court makes clear on page 195 of that opinion what it's really holding, which is that a state actor does not violate someone's due process rights by failing to prevent a private actor from inflicting harm on that person. Now, to cite that case, as the hospital does, is to assume their own conclusion that they are a private actor. Indeed, they are not a private actor on the facts of this case. They are a state actor.
How would you distinguish Lewis versus La Young, if I pronounce that correctly, wherein there was a state statute that provided a voluntary procedure, and the Fifth Circuit found that by using that voluntary procedure, it didn't turn them into a state actor?
Your Honor, I would distinguish that case the same way that I deal with Blum, the same way I deal with Flagg, the same way I deal with the Goss case. All of those cases are dealing with individual stars in the constellation that we have here. So our argument on state action, Your Honor, is quite simple. 046A coerces the hospital to provide care and then creates a procedure by which the hospital can get out from under that obligation by following state offered procedures, including a type of judicial review provided by the hospital's own internal ethics committee. And if it does all of that, then it becomes cloaked in what is effectively super-governmental immunity. And I say super-governmental immunity because the immunity they get under 046 is greater than the immunity that the state gives itself because it is not subject to waivers such as the Texas Tort Claims Act. So in a scenario like that, when in those constellation of facts, that leads to the conclusion under the cases that we've relied on, like West and Brentwood Academy, that's state action. Their cases, Justice Gabriel, like the one you referenced, pick out individual points in that in isolation and say in isolation, this does not create state action.
What is the state's position if we find the statute unconstitutional as to how this should proceed given the jurisdiction the trial court has over the child?
So, Justice Burwell, the state's position is that there's only one issue before the court, which is whether 046 is constitutional or unconstitutional. They have evoked 046 in announcing that they're going to terminate care. The plaintiffs have challenged 046 as unconstitutional. So the case or controversy that comes before this court is whether 046 is constitutional or not. We urge the court to uphold its fidelity to the Constitution and declare under the Texas Constitution that it is unconstitutional. May I finish answering the question?
Briefly.
So the next step after that is for the hospital to initiate some other procedure, some other case, to if it seeks to terminate care. But the point is that it cannot rely on 046. Thank you, Your Honor.
Four.
May it please the court. What the family, the doctors, and all of us wish is that this child could get better and leave the hospital, but it's not within anyone's power to make that happen. There's one question this court should stay focused on because it resolves the case. Does Cook Children's have a constitutional duty to provide artificial life support to any patient who wants it? The answer is no. And this court needs to look at only one case, the Supreme Court's decision in DeShaney versus Winnebago County. The plaintiffs and the state run away from this case. Just now, during the state's argument, that is the first time that either the state or the plaintiffs have even attempted to talk about DeShaney, recognized its existence. And in the state's case, that silence and its attempt right now to distinguish DeShaney on its facts is very telling because the state itself relies on DeShaney all the time to defend cases in which the state's being sued for failure to provide governmental services. And here's what the state said about it. This is in footnote 13 of our brief. In its brief in the Fifth Circuit, one of its briefs in the Fifth Circuit. There is no freestanding constitutional obligation for the government to provide services to its citizens under any circumstances. Here's what DeShaney says, and this is Chief Justice Rehnquist writing for the court. The due process clauses generally confer no affirmative right to governmental aid, even where such aid may be necessary to secure life, liberty, or property. It's not possible to get around this holding because that's exactly what the plaintiffs are seeking. The mother wants to force Cook Children's doctors and nurses to perform artificial life support that they believe is unethical.
Counsel,
if you assume,
can you identify for me any instance where it is not an exclusive prerogative of the state to involuntarily and intentionally deprive someone of their life?
I'm sorry, Your Honor, can you repeat that?
Let me repeat the question. how is it not state action here when clearly the 14th Amendment, in forbidding the deprivation of life without due process by any state, how is it not state action when here you have an involuntary, intentional deprivation of this child's life through the conduct of the hospital, okay? And only the state has that exclusive authority under parens patriae. I'm not aware of a single instance where any court has held that a private individual has the authority to take the life of another individual involuntarily and intentionally.
Your Honor, I have several responses to that question. The first is that the Supreme Court has held that when life-sustaining care is withdrawn, the patient dies of the underlying condition, not from the withdrawal of care.
But that case and every case like it deals with the Cruzan instance, which is a substituted judgment of the patient or of the patient themselves voluntarily asserting their own constitutional right to autonomy, has absolutely no application to an involuntary deprivation.
Your Honor, I think that's incorrect because Vaco versus Quill, where that comes from, this holding that I'm talking about, was a causation holding. That was what the court was discussing. And the importance of
Vaco was
Vaco...
also a voluntary situation because it was dealing specifically with a decision by a patient to voluntarily seek assistance in committing suicide. And the court made that decision for that reason. But again, the patient wished to die. Here, the patient's surrogate, the mother, is adamantly opposed to anything that would cause the death of her daughter, and Vaco doesn't apply under those circumstances. So again, give me some authority that says that the state is completely indifferent to involuntary deprivation of life by individuals.
Your Honor, of course the state isn't indifferent to involuntary deprivation of life by individuals, but here, and this is from the Supreme Court decision in Washington versus Luxburg, it's not correct due process analysis to look at the deprivation as a deprivation of life, to term it that generally. What Washington versus Luxburg says, and this is an opinion by Justice Rehnquist also, we have a tradition of carefully formulating the interest at stake. That's at page 722. It gave the example, Luxburg gave the example of Cruzan, where the parents articulated a very broad right, a right to die, similar to the right to life in this case. And the court rejected that formulation, restating the right more narrowly. The court did the same in Luxburg, rejecting the plaintiff's asserted broad right to basic and intimate exercises of personal autonomy, similar to the decision-making rights here at issue, or articulated. They rejected that in favor of a more specific right to commit suicide with another's assistance. So here, the specific right the mother asserts is what we have to look at, and that is the right to compel doctors and nurses to perform artificial life support that they believe is unethical. And this, at its base, is a right to government aid, which the Supreme Court categorically rejected in DeShaney. And I'd like to address the state's attempted distinguishing of DeShaney, saying that it only applies to, that the government doesn't have to help you, doesn't have to protect you from private violence. That's not true. Here's what the court said in DeShaney.
Counsel, just out of curiosity, how are we to find that, if we do get into the due process analysis, how are we to find that the hospital is somehow a neutral arbiter when, in fact, every bit of the evidence that was put on at trial and your argument just now is identifying a separate and distinct interest in the healthcare providers of their own, a right of conscience? So that is a potential right that is in conflict, potentially, not with regard to the right of the mother and the right of the child here. So how are we to find that, in fact, this statute creates a neutral arbiter in the ethics committee under those circumstances when the entire argument being made is effectively a right of conscience on providers to not have to provide fetal care?
I'd love to answer that, Your Honor. I do want to make just one final point about VACO and about the state's attempt, about DeShaney and the state's attempt at distinguishing. DeShaney was much broader than that. It states, as I said, there's no affirmative right to governmental aid, even where such aid may be necessary to secure life. And it specifically deals, DeShaney specifically talks about health care in the context of an exception to DeShaney, which is that the government does have a duty to provide governmental aid for incarcerated people because the state has deprived them of its freedom. And this is discussed in DeShaney. And so there would be no need for an exception for health care for prisoners if governmental aid for health care, if you could sue for it under 1983. That is absolutely included under DeShaney, under the rubric of governmental aid. DeShaney cannot be limited as the state says. So about due process, we have not conceded, as the state so boldly asserted, that this statute doesn't provide due process. It does. And so what Your Honor was discussing earlier, where VACO and Cruzan come out, is that there is a vast zone of policymaking authority that the legislature has in dealing with these sorts of issues. And they, as Justice Scalia said in his concurrence, the Constitution has nothing to say about it. So this is a vast zone of legislative discretion, and the legislature took all those considerations into an account. It took the considerations of medical ethics. It took the best interest of the child.
Could you identify for me in either the letter from the hospital or in any of the testimony concerning the hearing that was actually done, any standard of ethics that was articulated or applied by the committee?
Your Honor, the letter from the Ethics Committee specifically talked about the benefits and burdens of treatment, that was...
Does it reference in any way, shape, or form a standard of ethics that is applied across every ethics committee of every hospital in the state of Texas or in the United States? Or is it an ad hoc ethics determination by a single ethics committee in this particular instance?
Your Honor, it's certainly, the duty to do no harm, the Hippocratic Oath, is the fundamental tenet of medicine, applied everywhere, to my knowledge. And that's what's at stake here. So doctors are supposed to relieve suffering, relieve pain. They're not supposed to cause pain. They're only allowed to do that when there is a medical benefit to be had. That's the only instance.
How do we determine whether or not there is a medical benefit? How do we weigh that against the pain and suffering that's being experienced? And how are we to determine, when we have nothing but the ipsa dixit of the healthcare providers here, that those standards were actually being applied from a due process standpoint?
Your Honor, the weighing of all of those complicated moral and ethical questions is for the legislature. That's a policy decision. And the legislature in this statute left that up to the physicians.
It doesn't define medically inappropriate, though, does it?
That's right. It's leaving it up.
And in fact, the letter itself refers to the best interest of the child, even though that's nowhere in this statute. We at least, with regard to best interest of the child, have some guidance in the family code. But we have nothing with regard to medically appropriate, what is or is not medically appropriate, and nothing like that's articulated in any of the testimony that we've seen.
Your Honor, we are not relying on the best interest of the child here. We leave that. We concede that that is the job of the mother. What we're saying here is she can decide the treatment for the child. That's her authority. But we can decline to participate based on medical ethics, based on the medically inappropriate nature of the treatment. And that is covered extensively in the testimony, the medically inappropriate nature of the treatment, because it causes extreme pain and suffering with no medical benefit. Now, that's not defined in the statute. The legislature, in its policymaking discretion, decided that that was a medical question to be left to the physicians. And here, in 046, which I would, that's, the fact that that is left to the Ethics Committee is entirely appropriate here, because this is the decision of one institution. It's not a decision about whether this baby can get artificial life support.
Should the public not be concerned that different standards are being applied in different places in the state of Texas?
The public, if the public is concerned, and then the public should go to the legislature. That is their remedy. And that is what Justice Rehnquist said in DeShaney, and that is what Justice Scalia followed up with in Town of Castle Rock. And here's what they said. They said, the people, for example, in DeShaney, in talking about there's no constitutional right to government aid, the people of Wisconsin may well prefer a system where the state is responsible for giving aid. And here's the quote. They may create such a system, if they do not have it already, by changing the tort law of the state in accordance with the regular lawmaking process, but they should not have it thrust upon them by this court's expansion of the due process clause of the 14th Amendment. That's Justice Rehnquist in DeShaney, and Justice Scalia follows up in Town of Castle Rock versus Gonzalez. The same applying to DeShaney, saying the people of Colorado are free to craft such a system under state law. So the Supreme Court has made clear that entitlement to government services is an area where the legislature has wide discretion. And the people of Texas, through their legislature, have done this. They decided what duty to impose on doctors. If the plaintiffs disagree, their remedy is with the legislature, but they cannot take a shortcut through the judiciary.
I have a practical question to ask you. Let's just say hypothetically that this court found 166.046 to be unconstitutional. Practically, where do we go from there? Does 166.045 or 166.051 come into play there? Or practically, under our standards of review, where do we go from there, in your opinion?
Your Honor, a holding that 046 is unconstitutional has no effect on the injunction that is the subject of this appeal, because we have authority under 045C and under 051 to withdraw life-sustaining care after we've given reasonable opportunity for a transfer, which no one disputes that we have done. So the injunction has to stand, even if 046 is found unconstitutional and the plaintiffs have not challenged these other sections of the statute. And even if, so...
Is there any case law that you have that would arguably support that? Because we ask about the common law, and I believe you in your response, in your briefing, you said you found no cases. So is there any case that you have to support that?
Your Honor, there are no, as we said, there are no cases in Texas specifically about the withdrawal of life-sustaining care. But the background common law in Texas about the voluntary nature of the physician-patient relationship completely supports this argument. And those were adopted essentially and codified by the legislature in
the case law in the state of Texas deals with the withdrawal of a physician from the physician-patient relationship. Are you aware of any cases that deal with the right of a hospital to withdraw from a hospital-patient relationship?
No, Your Honor, I'm not aware of any cases in that way.
So in terms of whatever common law there is, that's strictly because the right to direct patient care rests with the physician as part of their authority to practice medicine, correct?
Correct.
Okay. So the decision to terminate life-sustaining care is not necessarily the hospitals, but would be the physicians.
That's correct, Your Honor. In fact, Cook Children's Hospital couldn't, if all the physicians in the CICU and nurses decided to walk out one day that they weren't going to treat this child anymore, there's nothing the hospital could do about that. That's up to the physicians and the nurses individually. And that brings us to the right of conscience at issue in this case. To not give effect to a right of conscience here, has enormous ramifications. This right of conscience that these doctors and nurses are asserting is no different from a doctor who refuses to perform an abortion. In both cases, the doctor believes she is being compelled to harm another person and is compelled to refuse to do that by ethics, conscience, religious belief, any of these.
Two things. One, is there any mention of any rights of conscience in the actual written decision from the Ethics Committee? And two, where in the legislative history of 046 is there any indication of that being a provision with regard to the rights of conscience of healthcare providers?
Your Honor, in the Ethics Committee letter, there is a mention of the benefits and burdens to the patient. That is what that means, the burdens on the child
So the
from this
benefits
treatment.
and burdens to the patient is somehow now addressing the burdens on the healthcare providers for the patient?
Absolutely, because the burdens on that patient are, while the physicians and the nurses who are treating, who are imposing that painful treatment, they know that that causes pain and suffering to the patient, and that's what causes moral distress to them. So that's absolutely what that means. And the rest of your question, Your Honor, was about the
Question
legislative...
was whether or not that was a consideration with regard to the enactment of the legislation to begin with, as far as any legislative history.
Yes, Your Honor. If you look at the, in our brief and also in the brief of the major right to life groups, the Catholic bishops, that group, it goes through the legislative history and all the testimony from physicians, from ethicists, from chaplains on this issue, about the ethical issue. So yes, it was absolutely before the legislature, and that's one of the rights they considered. And Washington versus Luxembourg specifically says that the state has an interest in furthering the ethics of the medical profession and keeping those intact. And I would also like to say, speaking of the amicus brief, if this statute really took people's lives, the major right to life groups and the Catholic bishops that helped pass it, that strongly support it today, that have filed an amicus brief, they would have been the first groups in here to attack the statute. That didn't happen. That's not what the statute does.
Time's expired. Thank you very much.
Thank you.
Mr. Nixon?
May it please the court, counsel, I want to make 3 quick points. Let me get back to answering your question. What you've asked for is basically, at what point in a person's illness do they lose due process or substantive rights? And the answer to that question is no point. So in relation to
That's part of the question. The real question is, if in fact the state does have an interest in alleviating pointless suffering of a child, okay, under parents patriae, how are we to balance that vis-a-vis the interest of the state in preserving the life of the child?
you don't have the record here to make that balancing act. If that's what the court wants to adopt, some sort of, you need to send it back. Remember where we are. We're only at the injunction stage. We're asking the court to maintain the status quo. Causing the death of the child is an adjudication of the case. We have to maintain the status quo, and then if we think we need to develop a record on that, we can. But I don't think we need to, because I think overwhelmingly, remember, the right to life and the right for a mother to decide what's best for her baby comes not from a law or the state. It comes from Deo, which is right here in this court. The amendment that we have to our Constitution are to protect those inherent rights. So the question is, well, is the doctor concerned about, is his conscience? Well, remember, there's not a record involving that. Those weren't the reasons, and those aren't articulated in the statute. So the fundamental question is that, are we going to adopt medical paternalism over autonomy? And the moment we do that, all 30 million Texans are in trouble, because that needle from, feudal care could be moved closer and closer and closer, because we've created an arbitrary needle. We've taken away from autonomy the person's right of self-direction. And the moment we do this, we're all in danger. Now, the second point I want to make real quickly is about the chaining. The chaining, the government does not have to provide care, but once it does, then it can't take it away. A third party can't take it away, or the government cannot take it away, remove it from you without due process. That's where we are. So the state of Texas and the federal government through INTALA, and the state of Texas through the government code 533.00253 says we are going to provide care for fragile kids. And Cook agreed to be that provider. It has accepted money from the state to do that. It has an obligation. So it can't say, well, no, we don't want to do this anymore. And to equate this to abortion is completely in opposite for this reason. If a provider does not want to provide an abortion, there's no patient-doctor relationship to begin with. Here, there has been one established for a year. You can't walk away or shrug your responsibility, your contractual duty, your doctor-patient responsibility, because I don't want to do it anymore. I don't think it's in baby's best interest. That's not what we allow a state actor to ever do. That is why it is a violation of due process rights. So, I would ask this court, what do? You issue an injunction. You reverse, render, issue an injunction. You send us back. We'll develop whatever kind of further record, but maintain the status quo throughout the pendency of the trial. We do not have a situation where the state has asked to intervene, and quite frankly, the state has said, don't do it. The only party that wants to terminate baby's life
actually,
is the hospital.
The governor and the AG don't have the authority. The Department of Family and Protective Services do, in fact, have the authority. Unfortunately, the statutory definition of neglect doesn't appear to address this particular situation.
No one's, I mean, this is a caring, concerted mother who's with her baby daily in the hospital.
Understood.
So there's no one saying she's not a good mom. All we're saying is that Cook's saying, hey, we know better. We know better than you do. And the minute we allow a third party to tell us that they know what's best for our life, we are all in trouble. All 30 million Texans. Don't do it. Issue the injunction. Thank you very much.
Thank you very much for your arguments. We recognize the difficulty of this issue. Your case is submitted, and you are free to go.
All right. The Honorable Court of Appeals for the Second District of Texas now stands adjourned. You dismiss.